ballistics reports from the Hartford Police Department that connected the weapons used in Bridgeport and in Vivo as involving the same .40 caliber Smith & Wesson pistol. As to the Bridgeport incident, I will not allow evidence of the Bridgeport incident to be introduced as third-party culprit evidence. The only connection between Mr. Bradley and that shooting incident is the fact that there is a ballistics match between the firearms used in both incidents, or firearm used in both incidents. But in the Bridgeport incident, there was no identified suspect, no description of any suspect that could match Mr. Bradley, and no other connecting links other than the ballistics similarity or match. That takes us to the Hartford incident. I've had the opportunity to review the videotape that was submitted by the defense. It is a video, I take it from the Vivo lounge, showing the front landing to that lounge, showing a small portion of the sidewalk in front of the lounge, and showing the bar area inside the lounge. I've had the opportunity to view that video on a number of occasions, that is, watching it repeatedly to make sure that I understood what it was purporting to show, and then considered that evidence in connection with the defendant's claim that the Vivo incident constitutes third-party culprit evidence. As we discussed yesterday, third-party culprit evidence, so-called, is evidence of other conduct, other acts that have a substantial probative value to some issue in the case before us, that is, the Boston shooting. The third-party culprit evidence is intended to prove that a third party, rather than the named defendant, committed the crimes that are underlying this case. It is not offered or admitted simply to create a reasonable doubt or to otherwise undermine the evidence that the state is seeking to present. Therefore, we begin with an analysis of whether or not Mr. Bradley's conduct at the Vivo Lounge in February of 2014 has a rational tendency to prove an issue in this case. I take it the issue in this case that it would focus on would be the issue of identification. That is, whether Mr. Bradley, rather than Mr. Hernandez, was in fact the person shooting from the Toyota 4Runner seen in various videos, and for which testimony has been offered. So it's admissible or offered for the purpose of demonstrating the identity of the shooter. In that regard, there are some at least surface similarities between the Vivo Lounge incident and the Boston incident. Both occurred with some connection to a nightclub or a lounge. Both occurred in the evening. Both involved a gun either located in or retrieved from a car, and both involved a discharge of a firearm at others. In the Boston case, a discharge at very close range. In the Vivo case, the shooting or discharge of a firearm by Bradley into and around the windows of a nightclub that was occupied at the time by numerous others. There are dissimilarities. The incident is somewhat remote in time. There's a 19-month time gap between our case in July of 2012 and the Vivo Lounge shooting in February of 2014. The Vivo Lounge shooting occurs after Mr. Bradley has been located by the Commonwealth, has entered into a cooperation agreement with the Commonwealth, and indeed has provided testimony before a grand jury in the Boston case. Other dissimilarities include the fact that the Vivo shooting appears, as I've heard from counsel in their proffers, and somewhat reflected in the videotape, appears to arise after a face-to-face altercation or argument of some nature between Mr. Bradley and at least one other third party. I note on the video you really don't see the nature of that altercation. It's not captured on film, although you can see that some bodies are just off camera or barely visible on camera. It also appears from the Vivo Lounge video and the facts as represented by the parties that Mr. Bradley retrieved a firearm, apparently from a vehicle. I take it that's not in dispute. After he had been shot. Mr. Bradley was shot in the groin area. He then confronted or faced various people, then turned and walked away, apparently to a vehicle. Came back some seconds later, perhaps 30 seconds to a minute later, now carrying a firearm. It is obvious on the video that he has sustained some injury, as our crime scene people would describe it. There is RBS expanding around his crotch area, apparent blood from his own wound. Mr. Bradley then tries to seek entrance into the club, carrying or holding a firearm in his hand, and unable to get in, the door apparently being locked, he then fires at the building, apparently. I take it that really isn't disputed, and some ballistics evidence were recovered, or was recovered, from the window frames around the club. It is the case that Mr. Bradley's shooting at the Vivo Lounge is, I suspect in his mind, defensive. It would not be a case of self-defense under the law in any way, but it would appear legally to be a retaliatory shooting. There is no claim before us in the instant case that the shooting of Mr. DeBreo or Mr. Furtado is similar in the retaliatory nature of the shooting, other than motivated by a spilled drink or disrespect of some sort. The question then is whether or not Mr. Bradley's carrying a firearm in a vehicle and then producing that firearm and shooting at others or intending to shoot at others is so similar that it has a rational tendency to prove that he would be the shooter in our case. Viewed or considered solely in a vacuum, one might suggest that it does. That it involves a nighttime shooting in a public place, some connection to a nightclub, and shows somewhat of a brazen use of a firearm to shoot at others. It might suffice to establish a reasonable doubt. The question is whether or not it is sufficient to create a rational tendency to believe that Bradley was the shooter in our case. And viewed again in a vacuum, one might suggest that it proves that as well. However, the Commonwealth suggests that on the facts as presented here, it would not be appropriate to view this in a vacuum, but all of the evidence, all of the facts surrounding the defendant and Bradley would have to be explored. That takes us to similar conduct on Mr. Hernandez's part. That is the fact that Mr. Hernandez has been convicted after trial of shooting another person at close range in a public place late at night, the firearm involved in the defendant using a vehicle. So there are similarities between Mr. Hernandez's prior conduct for which he was convicted. In the Odin-Lloyd case, almost equal to the similarities between Bradley's conduct at the Vivo Lounge and the instant case. If the court were to allow one under the third-party culprit claim, I would be hard-pressed to see how I could not allow the other. And if I were to allow evidence of Mr. Bradley's conduct and Mr. Hernandez's prior conduct for which he was convicted, then what we are proving essentially is propensity on the part of the defendant, propensity on the part of Mr. Bradley. And suppose in common parlance, it might be a wash in the end, meaning that in the end, neither other act evidence has established a rational tendency to prove the issue of identification in this case. The second factor to be considered in third-party culprit evidence submissions is whether that third-party culprit evidence will not tend to prejudice or confuse the presentation of the evidence in this case. And I am firmly convinced that if this jury were to hear other act evidence relating to Bradley's conduct at Vivo Lounge and relating to Mr. Hernandez's conduct with regard to Odin-Lloyd, that we would end up with two other trials within a trial here. That is, that it would be prejudicial and it would certainly be confusing to the jury. Accordingly, it is my view that the third-party culprit evidence, that is, the specific conduct surrounding the Vivo shooting, is not to be admitted. It is remote, as I indicated, and it would lead to prejudice or confusion by the jury. I'm going to have all of the material that was submitted in connection with this issue marked for identification, that being the Vivo shooting video. And Ms. Medina, I thank you for referencing the locations on that were helpful in knowing what to view. Mr. Sheehan, that will be marked for identification. As well, the series of police reports from Bridgeport, Connecticut, and from the Hartford Police Crime Laboratory.
All is one ID.
ID.
Yep.
And then I also received police reports relating to a 2006 task force investigation leading to an arrest of Mr. Bradley for drugs. I don't quite know why I have all of the reports. These are crimes that I take it resulted in conviction. And the conviction would be admissible to impeach Mr. Bradley, as would the convictions arising out of the Vivo Lounge incident. But they are offered then for a different purpose. They're offered to impeach credibility rather than to prove third-party culprit. But nonetheless, they will be admitted. There has also been testimony to this point by Mr. Bradley that he had access to firearms, that he had a familiarity with firearms. Indeed, that he purchased a firearm which he claims to have given to Mr. Hernandez. And that evidence may be fully explored in cross-examination of Bradley. As may be evidence relating to Bradley's drug activities, that being brought out on direct examination, and the defense has the right to fully explore drug activity by Mr. Bradley, or drug sales. So that deals with the third-party culprit claim and evidence, and that will be the court's ruling on the various motions to admit in the Commonwealth's motion to reconsider the admission of such evidence. Now, the second issue before me is the plea agreement that was offered as JJJ for identification, and in evaluating its admission. I've taken a look at several of our cases, most notably Commonwealth versus Champa. Mr. Hagan, did you intend to introduce this in your direct examination of Mr. Bradley?
I think it's more appropriate on redirect, Your Honor. My reading Champa and the other cases, and again, it would be subject to significant redactions. I believe one or two Champa mentions references to the obligation to tell the truth only. Obviously, the paragraph that indicates any factual representations also needs to be removed or redacted, as does the signature line, from my understanding.
Mr. Baez, are you familiar with Commonwealth versus Champa?
No, sir. But I understand its premise, and I take a different position. I understand Champ's there as a protective measure for the defendant. But we're certainly able to waive those issues if we certainly think it's to our benefit.
And is that your intention?
Yes, sir.
To have the plea agreement introduced or a cooperation agreement introduced in toto?
Correct. Actually, yes. Yes, I do.
And why is that?
Because I think it's beneficial to the defendant. I can bring that out during cross, and then I don't. If Mr. Hagan wants to introduce it in the redirect, we can follow the right course.
Well, if it were introduced in redirect, it would be introduced subject to considerable redaction under Champa. Redactions being appropriate on request of the defendant. Now, before I make a final ruling, and before you state a final position, I'd like you or one of your team to read with some care the Champa case to understand how the SJC is focused on this issue, and that's found at 406 Mass 257.
We understand, sir.
All right. Well, it's my thought, Mr. Baez, that if the defense, as a matter of strategy, if you make a strategic decision to allow this agreement in toto, or including the many references to an obligation to tell the truth, and as to consequences for not telling the truth, you're probably permitted to do that, so long as it is a reasoned matter of strategy. And so I think it would be helpful to have you familiar with Champa and then to express that strategy to me. All right?
I realize it's pretty close, but I haven't lost my head yet. So.
Okay. We'll take a look at the case just so you're familiar with how our court has looked at it.
Yes, sir.
All right, counsel, are we ready to proceed with our jurors?
Your Honor, just one housekeeping matter. I think Exhibit 294 was the last entered exhibit. It was the text messages. The Commonwealth didn't create a version, as the court instructed, to read text messages between Bradley and Hernandez as opposed to the opposite.
Yep.
And,
You've changed the heading?
We have, Your Honor, on each page of the document. So I don't know if the court wants to just substitute the...
Yes, the jury hasn't seen the heading, and no other changes were made as to dates, numbers, times, or text.
No, Your Honor.
Mr. Baez, any objection to simply substituting
No, sir.
to 293, 294?
Do you know how long you've been administrating?
No, there's no need it to be returned. All right, counsel, I don't see a need to mark the prior text messages for identification. We're simply making a substitution here. So they may be returned to the Commonwealth.
Judge, in between cross and direct, there's some audio that I want to queue up. Can we take a 5-minute recess after?
Yeah, how much longer would you be, Mr. Hagan?
Your Honor, estimated about 30, 40 minutes.
Okay. All right, let's line our jurors up.